We're going to start the next panel, which is going to be a very important panel in the area of collective bargaining, namely dispute resolution with regard to collective bargaining contracts and grievances. So it is my great pleasure to introduce the moderator for this distinguished panel, which is Homer LaRue. And I should tell you that Homer LaRue is no stranger to CUNY. He was a founding member of the CUNY Law School, founding faculty member of the CUNY Law School, and before that he was a chief mediator for the New York State Public Employment Relations Board. So he has a very strong roots in New York. It's also, one thing that Homer is the current president of the National Academy of Arbitrators and is a professor at Howard University School of Law. It is very appropriate that the panel is being co-sponsored by the National Academy of Arbitrators because, as I said before, there's a long historical connection between the National Center and the National Academy. And one of the things that we be mindful of in terms of memory history is that the first National Center Executive Director, Maurice Benowitz, was a member of the National Academy, and also the original proposal for this center all those years ago, 5 decades ago, was Donald Wallet, who's also a National Academy member. So we're very, very pleased to have the Academy and the distinguished panel of arbitrators here today. But lastly, for advocates and parties, I should just, before I turn it over to Homer, I should just emphasize that I've been assured by the panel of arbitrators that they will not be making any rulings today, but rather will be reserving judgment.
Well, welcome to everybody, and thank you, Bill, for the introduction. Let me, unlike what Bill said, we will be making rulings, and here's my first one. I can't get it out of my system. I've been doing it for 40 years. We do have a program itinerary, and I'm going to explain that to you and then get right to it. We are going to have each of the panelists make a brief statement, a 5-minute statement, and then we're going to move into a question and answer period. We'll leave time at the end of the program for Q&A. So we hope that our discussion among the panelists will invoke a lot of questions, a lot of comments, and we encourage you to engage the panelists and one another at that time. I'm going to first introduce myself to say 2 things, or at least one thing. Any comments that I make here today are mine, and they do not represent the position of the National Academy of Arbitrators, nor do I speak for Howard University School of Law. Now, at the admonition of one of the panelists, I do have to say this, that if I say anything erudite, I have to attribute it to Rosemary Townley, who's taught me, she tells me, everything I know about labor relations. Let me introduce the panel. On my far left is Jackie Drucker, Jacqueline Drucker. I will be calling her Jackie during the course of the panel. We've known one another for a long time, as all of the other panels. Jackie was admitted to the National Academy of Arbitrators in the last year of the last century, and since 1990, she has maintained a nationwide practice devoted to the arbitration of labor, employment, and complex commercial matters, having previously worked as a management-side labor lawyer and as a union lobbyist. Since the mid-1990s, Jackie has been affiliated in various capacities with the Cornell University School of Industrial and Labor Relations and the Scheinman Institute on Conflict Resolution, for which she has taught numerous programs, including training seminars for labor and employment arbitrators. Jackie is the author of Collective Bargaining Law in Ohio, which has been cited by the state's highest courts. She has also served as a senior editor of multiple arbitration treatises. Next to her, coming this way, is Howard Edelman. Howard is a member of the National Academy of Arbitrators as well, and he has been a full-time labor and employment arbitrator and mediator since 1982. and has presided over 8,000 hearings during that time. Howard serves as a permanent arbitrator in over 100 collective bargaining agreements. One of Howard's most significant joys, take this with a grain of salt, it says that the most significant joy in his life is that he is the husband of Rosemary Townley. Isn't that sweet? And last but not least is Rosemary Townley. Rosemary is also a member of the Academy and has been an independent full-time arbitrator and mediator, and she has heard thousands of cases in the labor management, commercial employment, and international sectors. Over the years, she has been named contract arbitrator in hundreds of collective bargaining agreements, including the National Football League and the NFL Players Association. She's a former adjunct law professor at St. John's School of Law in Queens, where she taught collective bargaining. Rosemary also holds a PhD from Syracuse University and a JD from Brooklyn Law School.
Thank you, Homer. He's such a great pupil. I know. I can't believe you said that. Okay. All right. I, too, must start with a disclaimer today. I am one of 3 members of the New York State Public Employment Relations Board. And my comments today are in no way reflective, condoned, approved by that board. The board is responsible for not only public sector issues, a small segment of private sector work, and of recent note is farm workers. They've been included too. So they have not approved this, and perhaps they would not. I don't know. In any event, yeah, one child, thank you. Either Bill or, what's her name again? I'm sorry, Homer, yes. I couldn't, you know, I just turned 71, and all of a sudden, I'm not remembering names, and it's horrible. Anyway, we mentioned Dr. Maurice Benowitz, the first director, professor of economics at Baruch at the time, but first director of the National Center. Now, I met Dr. Benowitz when I was first starting out in arbitration. I'm one of the baby arbitrators, as they used to refer to us. We were in our late 30s, early 40s, and he was hearing a case at the American Arbitration Association. So I waited outside the room, and I thought, I'm going to introduce myself. You know, I'm going to get up the courage and everything. He finished, I walked in, and I said, Dr. Benowitz, my name is Rosemary Townley, and I'm a new arbitrator. And he said, why does a cute little girl like you want to do arbitrating? Now, happily, those days are done and over, and so is the cute little girl part, now that I have so many senior cards. But in any event, the composition, and I'm going to talk a little bit about demographics of arbitrators, the composition of the arbitrators in the early days, now that would be going back to 40s, 50s, and 60s, really came from the so-called National War Labor Board, which were convened both by President Wilson and FDR, most notably, to resolve disputes during the wars so that it would not grind the economy to a standstill. And accepting Professor Gene McKelvey, the late Gene McKelvey of Cornell University, it was all men. Of course, it's all men. Rosie the Riveter wasn't even invited to serve. And even today, the numbers have not changed dramatically. Homer will probably talk a little bit about some of the initiatives, but as far as the National Academy of Members is concerned, which takes probably about 5 years worth of experience and a number of other recommendations to get into, as of their 2023 report on diversity, equity, and inclusion, only 7% of the arbitrators are of color. None are disabled, or no statistics, rather, on disabled and LGBTQ and other groups. And the labor neutrals, and this comes from the Academy Proceeding, which is the annual meeting of the Academy, 83% male, 17% female, white, non-Hispanic, 95%. I'm not quite sure how that was categorized, non-white, 5%. So you can go to meetings today and feel as if you're attending a meeting of 20 years ago. And I think what strikes me as I was reviewing these statistics is that there's a saying more in international arbitration, Jackie, I'm sure you've heard it, and that is the neutral pool is male, pale, and stale. And what I love is that all of the older arbitrators and professors of law and so forth will cite to that and say we need to make an effort. But the statistics that have been garnered on international arbitration, I think perhaps it's 1%, are even women. I don't even think they've moved to people of color. So it's truly sad, I believe. Homer, you will address the initiative, I assume. I just want to note there are efforts being made. Currently, I'm part of a group from Jackie Scheinman Institute in Cornell, ILR. We'll be doing a program in a few weeks. Again, trying to match up users along with those that send out lists of arbitrators. I mean, the stakeholders really are the key. You can, 2 minutes, really? Okay. You can do everything possible to try to populate the panels, but if the advocates do not choose you, where are you? And what has bothered me is I've even seen folks on these panels with me when we're developing new initiatives say, well, you know, I won't use anyone unless I know them. Well, how do you know them until you use them? I heard that 40 years ago, so that hasn't changed. So the goal, you'll talk about the goal of the initiative, and I have all of these statistics, which I will not get to now. But in any event, I'll be around for questions. Thank you.
Thank you. I'm not that much younger than my colleagues, but I started in the 90s, and all three of my colleagues here today, Rosemary, I think you were one of the first people I met when I came to New York and said, I'm going to be an arbitrator. And Rosemary and Howard and Homer were tremendously helpful as I built my practice, and that's one of the attributes of the National Academy of Arbitrators is this commitment to helping to bring newer and aspiring arbitrators along and helping them to perfect their work and also to build their practices. But even then, a little later than when all of you were admitted to the Academy, I still very often went into hearings and would be called Mr. Arbitrator. And whoever called me Mr. Arbitrator then would be terribly flustered and upset, and you know, we try to put them at ease. It still happens every once in a while, still. But I wanted to look back and look forward. But in the looking back, I contemplate not only the nature of the arbitrations I've handled in higher education over the course of 30 years, but also the nature of this program offered through this center, these conferences. And Bill provided, in addition to his marvelous paper tracing the history of the National Center, the agenda from the first of these conferences in 1972, which was featuring Dr. Benowitz. And that program, what I find interesting, focused heavily on the basics, on nuts and bolts, on training, really, for the handling of grievances and presentation and arbitration, rather than the lofty and intricate issues and robust discussions that are on your agenda for the next few days of this program in 2023. And that made sense, because 50 years ago, as Rosemary had outlined, the process was still emerging and it was still taking shape, especially as to collective bargaining rights and processes in the public sector throughout the country. So with that backdrop, then I kind of look at my cases and the evolution of those cases from higher education that have crossed my desk and made their way through my legal pads, and then in more modern times through the 20 laptops I have used and abused over the course of the decades. And I see the increased sophistication of the issues and the advanced caliber of advocacy that we see in our forum, and also the increased intricacy of the cases presented. And I think of all of the industries in which we as arbitrators work, higher education does tend to be among those that are more sophisticated and also more complex. This is in part because of the great expanse of the types of functions and disciplines that are involved in this huge umbrella that is providing higher education to the world. In addition to that, though, I think the complexity emerges from the procedural points, given the kind of multi-layered administrative structures and internal dispute resolution systems that exist in many institutions of higher education. So with these factors can come more convoluted issues that are presented in arbitration and the increased likelihood that there may be threshold issues, such as arbitrability, motions of infinite variety, issues of election of remedies, questions of specific aspects of due process, and complicated evidentiary matters. And then you add to that the fact that the participants in arbitration, who come from higher education, the parties, the witnesses, tend to be fabulously well-informed, thoroughly engaged, not strangers to complex analyses. And, no, it's not always, and accustomed, I don't know if this is good or bad, accustomed to holding forth on especially those topics that affect the work for which they're responsible. So all these factors, I think, tend to make arbitration in higher education among the most fascinating and enjoyable, but also among the more challenging. And there's a risk when arbitration gets peppered with detours and mired in complexity that we lose the goal of efficient and simplified resolution of disputes by a neutral while ensuring full due process and careful development of the facts and theories under the umbrella of our neutrality. So with this, looking forward, I offer a modest hope, thanks, and a suggestion for the future of arbitration, which is that all of us involved in the process should remain vigilant to maintaining the balance between the quality of the resolution and the process that we provide or participate in, and the need to make it streamlined and efficient. If we apply ourselves in terms of preparation, and not just for preparation of the case from the standpoint of advocacy, but with an eye toward efficiency, and even involving the arbitrator maybe earlier in the process than is customary, I think we can substantially increase the efficiency and the grace, of the arbitral process without losing any of the procedural protections and critical substantive content. So in the big picture, it's my hope that advocates will look not just for ways to prevail, but also ways to make the process work the way that it should, so that we can keep our eye on what the promise of arbitration has been all these 50 years.
Howard?
I don't belong to anything. No disclaimers. I've just been doing this for 40 years. And in listening to the prior panel, in listening to the prior panel and hearing some of the comments when I spoke to people during the break, I decided just to talk about two very different topics. And like Rosemary, we'll stay as long as you want after to talk, because I think that's where really the good stuff goes on. But in any event, I haven't used her 20 laptops. I still use chisel and stone. I find it the most effective means for communication. You folks heard a lot, and some of you spoke a lot about part-timers and their increasing needs and increasing demands, and that's great, and that's right. I want to suggest that there's another group coming on. Any of you get The Chief? Know The Chief? The Chief is a really good publication. It's a weekly publication put out in New York. It's basically labor relations in the New York area. Well, the New York area, though they cover some others as well. It's pro-union, but that's not the point. It really has its pulse on what's going on in the labor scene, both public and private sector. And I cut out the latest, I know it's not the latest, but I think it's 2 issues ago, this article, Professors Unions Flex Muscle. I know some of you are amazed that you have this muscle to flex, but that's largely true. Over the years, I mean, in the late 70s, I can remember when full-time faculty unions disdained and would not take part-timers into their union. And you think that's It's crazy, but that kind of theme or attitude was prevalent. And now, as I said, we heard a lot about it, and you heard a lot about the part-timers' role. Well, there's a new group. I'm quoting, his name is Remus, or whatever. He said that he hopes to build on the power that unionized adjunct faculty and graduate students at NYU have established in recent years, and looks to follow the militant example of the professors at the new school. Now, I'm not advocating a strike, but I'm saying that this is a relatively new trend, particularly with respect to graduate assistants, doctoral students, resident assistants, the folks who work in the halls, that better than I do. And it's a growing area. In fact, I've supervised a couple of elections for these groups of people. And later on, we can talk about it if you're at that point in your union activity, but we can talk about the nuances of that. What was that? 2, okay. So the second thing I want to echo, but in my own crass way, what Jackie said much more fluently. The point about the arbitration process being overly complex and overly imbued with hyper-legalistic arguments. I'm from the, tell me your story school, with due respect for the law, obviously, but that's what I want to hear. As you folks know far better than I, there are people who want to tell you everything they know about their subject matter from, the time of the flood. When I do seminars, and this doesn't offend anybody, but if it does, too bad. When I do seminars, and I do a lot of them on training advocates and the subsection of preparing witnesses, I say what you want to do with your witness is, first, if possible, you want to hope he or she has had a lobotomy. And the reason for that statement is you want this clear, simple response to your questions. And you don't want to give them the narrative to go and expand upon the world as they see it. And I think, and now being serious, I think that's particularly a problem in higher ed. And it goes toward, and I'm getting echoing Jackie, it goes toward for a more streamlined process. And it's hard for you to do. I regard you as the advocates in higher ed, both sides of the table, obviously. And I think you have to exercise, frankly, more control over your witnesses. Now, it's hard. You have politics, whether it's on the, on the departmental side, and the chair has to explain why John Smith didn't get this promotion, and on the union side, when the professor has to tell you all the wonderful things he or she has done. But I think not only is it good for the process, it's also good for your cases. And I want to end on that note.
Thank you. I will say one thing. As a faculty member for the last 35 years, good luck. Another point I want to bring out that Bill's article I want to recommend to all of you. It's an excellent history of the center and the development of the center. Bill, I learned something. There was a meeting in 1970 in which the statement was made by one of the conveners that CUNY and UFCT had entered into the first faculty collective bargaining agreement in 1969. Bill corrected that. Howard University was among the first universities to enter into a collective bargaining agreement with their faculty, not the law faculty, and for some reason, not the rest of the faculty anymore. Why, I don't know. So what we want to do now is to turn to some questions that, since all the panel members have staked out some territory, let's do a little looking back and looking forward. And Jackie, I want to start with you. And I want to ask you something that all of us still remember very much, and that's about the pandemic. And what do you think has been the impact of the pandemic and related public health measures on the nature of dispute
are being arbitrated, both in higher education and beyond, if you want to comment on that.
You know, thinking back about, thank you. I can almost project enough, but thinking back about the pandemic, how many of you are from New York? Oh, a lot of you. So you all share the memory, and those of you who aren't from New York may be interested to know that, for example, at the end of March, beginning of April, there was a field hospital that was set up in Central Park, not just a few blocks from here, and another. The Javits Center on the Hudson River was turned into a medical unit, and the streets were largely empty, but for ambulances and essential workers. And that was when we initially thought it might be 2 weeks. You know, it might be 2 weeks, might be 3 weeks, and then life would return to normal. And then it gradually, we all became aware, I think, as a country, but especially here in New York, that this was something that was going to be enduring. And from this, I think as a profession, we assumed that there would be a raft of pandemic-related issues emerge through the grievance process that we eventually would begin to hear in arbitration. And of course, within higher education, there was so much, and I think early there was a level of complete fear as to what this meant for the future of your institutions. I have to say now, reflecting back on that, it is truly impressive how the community got through that and emerged from it and worked together, labor and management, and I think the degree of cooperation was really quite remarkable in enabling the institutions, the students, and of course all the employees to get through that and to come through it with not that many lasting changes, but some of the issues that emerged in arbitration you might expect. Use of sick leave, how do you deal with quarantine, things like that made their way to us. But there were some that I think you may be seeing actually at the bargaining tables now that raised fairly complex issues. One that I saw from a few different institutions in higher education and other entities related to the force majeure clauses in collective bargaining agreements or the catastrophic emergency clauses. And as arbitrators, we got to see the vast array of phraseology used for those terms, most of which weren't drafted with the idea of a pandemic that was going to last for years. And so we, I think, ended up exercising our contract interpretation skills fairly frequently in those cases. And the ones that emerged from higher ed and also other industries would first raise the question, does the pandemic qualify to trigger this force majeure or this catastrophic emergency clause? So that, and it turns so much on the way in which these are drafted, and the way they are drafted does vary significantly. Some tying in government-declared emergencies, others linking impossibility of performance or impossibility of operation as a factor. And that presented interesting issues for us. When you first then determine, does this particular clause, or has this clause been triggered? Well, what is the result of that clause? Why is it being implemented in a given case, or how does it relate to the dispute before the arbitrator? In some instances, it related to premium pay for those essential workers who had to report during a closure. But what's a closure, especially in an educational institution? When the campus is closed, but everything has moved online, is the institution closed or not? And those are the kinds of questions that we were able to deal with and had to resolve. Also, I saw an interesting number in higher education, but also in the private sector, of provisions that in the event this catastrophic event clause was triggered, an employer would be released from certain obligations. And one of the more interesting ones I've seen is the release from specific structures for layoff in a faculty in higher education, and how the layoffs ordinarily would be effectuated, But now, given the emergency and the restrictions and the financial straits in which the institutions found themselves, how would that play out when the carefully bargained structure is lifted because of a force majeure clause, and then the recall process that works? And one of the things I saw and I developed a new appreciation for through that process is the critical role of faculty involvement in search committees and the development of position descriptions and filling faculty openings, because some institutions ended up with the massive layoffs initially, depleting their resources, depleting the expertise that existed in a given department, and then having to go forward and make hiring and recall decisions as everything came back into full operation with a limited availability of the very expertise that was needed to design these programs and engage in these recall or hiring decisions. So that was an area that I found particularly interesting, the force majeure clauses. Then, of course, there were the vaccine mandates, and that, I think, both as to the employees, especially for institutions that have healthcare operations, all of those issues that were presented for that, I think are going to have some lasting effects. And also, and we'll talk a little more about this, the shift to online operation for what you do. We'll talk about what we do, but when universities move and colleges and other institutions move to operating substantially on virtual platforms, that raises a number of issues that make their way into arbitration, and I think those are there to stay and are being dealt with now as you move ahead with bargaining. But what kind of support needs to be required? How do you deal with scheduling and schedule changes? All of the evaluation criteria that now need to be tweaked because teaching takes place in largely in a different kind of format. I think those are a few of the issues that have lasting effects on what we'll be doing going forward.
Thank you, Jackie. Howard?
Yeah, just two other levels of impact. One, of course, is very, very major. This is the year of the nurse. Why did you have 5 strikes and about 3 or 4 near strikes in the metropolitan area? And I've mediated a bunch of them. A direct, it's caused a large increase in salaries, which is fine. I'm not criticizing it or condoning it at all. But that's a fact, and bargaining is, in the healthcare professions these days, is infused with, we paid our dues and more than our dues, and you have to respond. And one other quick level is you have had from the federal government and from the state government consistently changing protocols with respect to COVID and how the impact of COVID is to be applied in particular work situations. And that, and those changes, and those confusing changes, come up against collective bargaining agreements that relate to the use of sick leave and the like, and that's been an especially challenging field for arbitrators to deal with.
I think that's especially the case when the federal judges feel the need to jump in and or, of course, respond to filings on these issues, because you'll have the contract, you'll have a complaint from a group of police, fire, teachers, whatever, and the courts will look at it, very precisely, at times not even considering the collective bargaining to be relevant, just the law and the powers of the respective governments. So I think that was something that surprised me with respect to the extent it was, at least in the Southern and Eastern District in New York, the extent of the involvement, and then how it impacted with the decisions we already made, and then were kicked back. So, and I think there's still more to come. And just procedurally, with the use of, going back to March 2020, remember being in the middle of a multi-day hearing, and we had 2 witnesses left for the, if you will, defense. And the mayor, everyone, the city was shut down. And the folks went back to their jurisdictions. They couldn't get back in, and they wanted, this was 3 arbitrators, the arbitrators to travel to them. Well, we couldn't get out. And we had decided, could we compel the use of an online or Zoom hearing? Because at that time, it was unheard of. And we decided that yes, because otherwise, the type of prejudice to a plaintiff or an employee, if he or she has to wait until the end of the pandemic, which at that time, nobody had a clue. And this group of arbitrators I was working with, we came out with a very firm decision. We're going forward in 2 weeks, which was supported by the federal court. So there were little twists and turns in that regard that I think we're still going to see.
Along with that, also in March of 2020, when the whole dispute resolutions process came to a screeching halt, I must say that was one of the proudest moments for the National Academy of Arbitrators. Because as you may or may not know, we stepped up, formed something called the Video Conferencing Task Force, and first began teaching ourselves how to use video conferencing to keep the process going. And then we opened it up to labor and management. First, there was resistance, and it was resistance from both sides. But we came together in a way to learn how to do it and continue to do it. Now, that was because of the pandemic. And Rosemary mentioned the question as to whether or not an arbitrator could manage the process in such a way that the arbitrator says to the parties, we're going to go ahead virtually. If you haven't read it, most of you probably have, the Academy issued an opinion, an ethics opinion 26, which is worth looking at. What I'm, as president, one of the things that I'm trying to do is get the Academy to continue to look at video conferencing, not to close it off as something that was done in the pandemic, but to look at it as a possible way of moving forward with the input of both labor and management. Because as the panelists have said, it's not going away. We saw it happen then. It's going to, the question of how to deliver the arbitration process efficiently and in a just way is still there.
If I may just jump in with respect to virtual hearings, because my caseload is virtually all virtual hearings. I have been shocked that the advocates in the New York regions prefer accepting some of your clients, police, fire, they prefer having that virtual hearing. You can see faces very closely. If you're at a live hearing and everyone's masked and you're far apart, it does make for some confusion at times. I like that I can control, with the push of a button, I can get the lawyers into one of the little rooms, I have a conference room, and say, what the heck is going on, et cetera, rather than pull them out in the hallway in front of their clients and start yelling. Not that I ever started yelling, per se. Yeah, I mean, my worst habit, I'm Italian, and I still talk with my hands, I guess. And I had a coffee cup, I'm in the hallway, and I did one of these, and there's a gorgeous silk tie that I completely destroyed, and I offered to pay for it, but then they know, well, if she pays for it, then is it somehow biased, and et cetera, et cetera. But in any event, and Jackie, I know you were going to get into it a little more, I believe, in terms of virtual platforms, but I think that's a whole new world. It's a whole new world, and I'm shocked at the sophistication of the parties in terms of using it. Whether it's depositions that later then lead to hearings, but as I say, I have found my wheelbase of clients to prefer it. I mean, Howard, you had something with a large client preferring it. Didn't you? No. I don't know. I don't.
No, look, the reason people don't, I think the majority do prefer it, the reason people don't like the protocol or the Zoom or whatever the platform is twofold. Some, pardon me, old fart attorneys believe that the only way they're going to win their case is Perry Mason-like, that dates me, I know, is Perry Mason-like, get that witness right in front of him and just grill him or her, till they wilt. A, that doesn't happen, and B, it's really just out of place and out of date, I think. The other attitude is totally different, and it's more interesting, I think. There are a number of people, advocates, not advocates, constituencies. Rosemary rightly mentioned police and fire, United Parcel Service workers, by the way. And their view is they spend every day on the streets interacting with the public, so damn it, you better be able to do the same thing. I'm not sure I agree with that. I mean, but I understand it as opposed to simply the method of, putting a client on the stand or an adversarial witness on the stand.
I think
He's
that,
had COVID, I have not.
right.
Just for the record.
Yeah.
Yeah.
Jackie, one last statement with regard to, do you see anything particular about the virtual hearing in higher education, either looking back or looking forward?
Well, I think a great amount of our time in March and April and May and even into 2021, I think as arbitrators, I suspect it was the same for the three of you, was spent kind of cajoling, educating, trying to persuade the parties and the advocates and the lawyers that we can do this on a virtual platform. Really, it's going to work, and doing demonstrations as to how it would work, and doing pre-hearing teleconferences where we talk through it and helping the advocates maybe persuade their clients. That really didn't happen in higher education because you all were transitioning to online operation and already had some experience with it. And so I found that the cases in higher ed much more readily moved onto the virtual platform, and everyone was already or rapidly becoming adept at using it and comfortable at using it, comfortable with using it. So I think that the process of familiarizing the parties and making them feel comfortable with the virtual platform was much, much simpler with higher education. But Homer, I also wanted to mention, just while we're on the topic, I said as the Academy was spearheading these incredible training programs almost immediately, and Homer was not yet president of the Academy, but he really was the force behind it. And it was almost immediate that we got up to speed and the arbitrators were able, those who I think would have never imagined that they could manage a hearing online were feeling comfortable and ready to do it and ready to convey that knowledge and skill also to the parties. But also, you were kind of prescient in this regard. In the fall of 2019 in Savannah at the National Academy meeting, Homer did a whole presentation on doing video hearings. And I remember how packed the session was. We were all on top of each other. It would never meet COVID restrictions today. But it was so well attended and everyone was so fascinated. And I don't think anyone had the idea in the fall of 2019 that we would that wave was just going to come crashing onto shore. But you began preparing us for it even before the pandemic arrived.
I think another very useful function that's come out of the whole wave of using virtual hearings is that, and especially for me with my higher education cases, I will set up a Zoom conference with the attorneys, with all of the stakeholders, whoever's going to be involved in the hearing, so we could plan hearing dates and plan for the exchange of exhibits and so forth. Because one of the things is I found always to be very problematic is getting a date. You offered a date to AAA, they send it to the party checks with their party. 3-4 weeks later, you're onto it. But if you can just sit there and do a Zoom conference, everyone opens up their calendars, and even at the conference, you might be able to resolve a few of the smaller issues. Clearly not the major ones. But it's a more efficient way of moving along in arbitration, and as arbitrators, that's part of our charge. We are to be efficient and effective. So I'm all for it.
Let me move us along. We could stay on this and do an entire panel, and if you have questions, we invite you to have questions. I want to turn to Howard and turn to your opening statement a bit more and ask you, what remedies do you think that employees are looking for in terms of this new contingency of people who are looking to be organized, and what kind of procedural rights do you think are involved?
Yeah, you have a division in part between the private and the public sector. As you know, you're covered under the NLRB in the private, and you're covered under this thing called New York State Public Employment Relations Board, whatever it is. I never heard of it. But in any event,
Your wife's place of employ.
in any event, so there is a bit of it, and the rules are not, they're not identical. But I think the key issue is, let me preface this with a question. Are any of you involved in organizing, not representing, but organizing new higher ed groups, such as, there are a couple? Okay. Well, it's really, well, let me put it this way. As I said before, it's going to come. And right now, only a few, but it's going to be here. I've supervised 2 elections in the last couple of years. And the mechanism really is a function of the relationship between the union that's seeking to organize and the employer. If there's a generally positive relationship, they will set out many rules, but the rules will, in effect, respect and endorse the neutrality of the process. And so, and I can't say the place, but in one university, which I'm doing now, the parties have agreed that the university will not oppose the right to organize, which they can't really, but will not oppose it. More important, the university will not publish any statement or make any statements from the university. You're not going to control what an individual professor does, but will not make any statements from the university urging this new group to vote against representation. That's a big deal. I mean, that's a really big deal, because you always have the answer of, not the answer, the concern among people who have not been organized. Well, they're going to retaliate, they'll do this, they'll do this, they'll do that. And in that instance, while there is an election, and there will be polling places, nonetheless, the neutrality of the employer will be affirmed. That is going beyond the law. The employer has a right, actually under PERB and the NLRB, to oppose to oppose representation. And in the other place that I worked at, the election involved about 1,800 adjuncts, 1,800, I'm getting as old as you.
You're older than me.
1,800 resident assistants, doctoral candidates, and the like, hotly contested. The procedure that was agreed upon was that I would, on an ongoing basis, because the election didn't take, the campaign took place over about 2 or 3 weeks, on an ongoing basis and on an emergency basis, either the union or the employer could come to me for a Zoom, go back to that, for a Zoom hearing to decide if there's been an improper practice, and I had a right to order a remedy and a retrospective remedy if I felt that. And it was a very close election. The union lost. Objections were filed. I ruled on the objections, and so it was a litigious, hard-fought process that there's still a lot of bad blood over. This is 2 years ago. All right. Employers and unions have the right to even forego an election if they have a mind to do that. They can simply do a card check. And the card, some of you have probably seen these, there's the cards that say, I wish to have XYZ union represent me in collective bargaining. And they'll bring in a neutral, and I've done this this is easy, it's really easy stuff, but many times, cross-check the signatures with the authorization for tax purposes, the W-9, whatever it is, cross-check the 2 signatures, and if the union, achieves a majority, the union wins. I have a new problem. What do you do with e-signatures? I don't know the answer to that yet. That's a real tough one. I don't know the answer to that one yet. You have a signature that's not a signature, but it's an authorized document. But it's something I'll have to grapple with. But there are a number of employers in higher ed and non-higher ed who have been, and I'll say this word, cooperative, and where there's a good relationship with the union, willing to do only a card check and sit down and bargain.
I guess it's not Jeff Bezos or Howard Strauss from Starbucks. I mean, that's the milieu in which we're working. And it's surprising that it is so sophisticated at the higher ed level with new groups. Although, I don't know, is Yale University still fighting with their research assistants and fighting the unions? That's been going on for decades. And they haven't been able to unionize. For a while, Columbia also. But the universities that did not expect to be, you know, fighting and using every available remedy, let's say, to try to keep the union out, still are at that game, which really surprises me.
Jackie, do you have an observation about? Well, then let me go on to ask another question. And as Howard, you were talking about this new group of employees who are seeking to be organized in higher education. We've all dealt with conflicts with regard to faculty when grievances arise, because obviously somebody's ox, or somebody feels as if their ox is being gored. And it puts the union in a particularly difficult place and puts management in a particularly difficult place as well. Do you see those kinds of issues arising with this new group that's seeking to be organized?
Part of the answer is I don't know, because they're new groups and they have not been organized in the past. But I do know that in many areas, not only in higher ed where you have the supposedly, I shouldn't say normal, but the understandable conflict of the faculty senate who votes to implement or not implement a particular policy that the union does or does not favor as a separate entity. So those are very big conflicts that, frankly, a lot of you know better than I. You have, of course, as I alluded to before, the department chairman who denies tenure or does what he can or she can to deny tenure versus the representation of the member. You have other kinds of issues, more so in the non-academic area. You have standard seniority issues. Seniority by nature is a confrontational issue. Unless the claim of the union is you improperly laid off 5 people and we just want you to add the 5 people, which occurs fairly rarely, but the real issue is if you bring back 5, the employer has a right to lay off 5 others, presumably in appropriate seniority order. So those kind of conflicts arise repeatedly. Many unions do not allow their own counsel or representatives to represent these individuals. They go to outside counsels so as to be absolutely, quote, neutral with respect to the advocacy that they present. It's a big issue. It's a costly issue for unions if you have to go outside. It also involves factions of the union in terms of who prefers who's in favor of who. So it's ongoing, and we still got to face it. In terms of the new groups, I'm desperately thinking of an answer, Homer, and I don't have one.
Well, I have one observation from my own experience. I was the arbitrator, one of the arbitrators for the California Faculty Association and California State University for about 10 years. And I think the one thing that I observed as I look back is better understanding and better appreciation by arbitrators for the distinction between what we could do and could not do. We were really there to see, was the procedure followed? Not to make the determination as to whether or not tenure should have been granted or tenure should not have been granted. That's an academic issue, and interestingly, it goes back to Professor Benowitz's paper to 1973. I think over the 10 years, I saw better understanding, deeper understanding, and appreciation by neutrals of that distinction and being able to make that distinction in a more thoughtful and reflective and helpful way to the parties.
See, I totally agree with that, but that does not impact the intra-union, not really warfare, but disagreement and concern about the resolution. Yeah, I mean, it's a cliche, as you know better than I, although I've done a lot of higher ed cases. that the arbitrator can rule on procedure, but not deal with the merits. And we both know how it's so clever how you can slide the merits into a procedure argument many, many times. But we are sensitive to that, and we have to be.
Jackie?
There's also the procedural element, which I think probably in non-faculty, at least under New York law, where there's an incumbent who has, and there's a promotion issue, and you've got the incumbent who's going to have to go somewhere else if a promotion has been found to have been wrongfully given to that particular person. But the problem with that starts at the beginning of the hearing, and it's one of those things that I hope in future it can be dealt with before the hearing, in that the incumbent, and you would think, in a more sophisticated workplace, the incumbent's going to know what's going on, but very often in laborer-type positions, the incumbent is not aware that their job is in jeopardy, and notice must be given to them of the hearing. They have to have the opportunity to be present at the hearing, possibly to seek legal counsel at the hearing. And so in the public sector in New York, we lose lots of hearing days because that incumbent hasn't been fully apprised of their rights. And that's one of the things that I try to be on the lookout for, but you don't always know because we don't sometimes know what's going on in a case until we show up for the hearing.
Let me move on and to another area that Rosemary opened up for us, and ask you, Rosemary, to look back a bit and talk about the demographics that you've, demographic changes that you've seen, both in terms of who's making the decisions, who's coming before you, who's being impacted.
What I found interesting was perhaps 20 years ago when I entered an arbitration hearing room, virtually every person sitting at the table was female. It was the first time I had ever encountered that. Counsel for both union and the school in this case were female, and everyone almost seemed shocked and didn't know what to do. It was such a nice, calm hearing. I mean, really, you didn't have too many egos being, stroked or anything like that. But on a serious note, there are, many newer attorneys that are coming into the profession. I guess the one problem I have is the legalization of the process, because they tend to be litigators to begin with, and they want to use their skills in the arbitration. And whether, as Jackie said, it's a motion or some type of other action that could slow the hearing down, you need, as arbitrator, to push back and say, whoa, we're not doing that. This isn't a courtroom. You don't see a robe, right? And sometimes they will get offended. And then many times the next session will have, the elderly, the wise elderly attorney that's usually second seating a new attorney or a new advocate, whatever, come in and kind of show how it's done. We have to get along here. And I find that to be refreshing. I don't know what's going to happen, though, when that, upper layer retires, dies out, and so forth, because it's almost like I hate the word because it's used all over, but the weaponization of legal tactics within the arbitration forum. And, you better, in the olden days, as they say, you didn't need to be an attorney to handle arbitrations. Those days are long gone.
I once had, 30-second anecdote, I once had a new attorney come before me, and he represented management, and he said, Mr. Arbitrator, we believe the contract under which the union is arbitrating is void and unenforceable. So I said, okay. I said, why is that so? He says, it violates the rule against perpetuities.
Which I still don't understand.
Who does?
Still do not understand.
I defy any lawyer to define the rule.
Some of the newer advocates, and I should not do this, and I haven't done it really in 10 years, but I remember one very nervous newer advocate. We're doing our sidebar in the hallway, and he says, what do I call you? And I said, well, you can call me Madam Arbitrator, Miss Townley's fine. I said, but I prefer Your Royal Highness. I run into the room, and the poor kid, he says, Your Royal Highness, this is a very simple case. I kind of liked it.
You would.
Never did that again.
I wonder, one of the questions that I see on the rise a bit, and I don't know if it's in higher education or in others, the use of dispositive motions. What a dispositive motion is, for those of you who are not accustomed to that language, it means at some point in the arbitration, one of the parties says the other party hasn't met their burden, and therefore, Mr. Arbitrator, Ms. Arbitrator, what you ought to do is grant a dispositive motion in my favor and not let the hearing go forward. Don't hear any more facts. You don't need to hear any more facts. Rule in my favor. That's what the moving party is saying. Do you see that in higher education, and has it gone up, gone down?
I was going to answer it, but not with respect to higher education. I have a simple view about them. They suck. I mean, and I mean that, I kid around, as you know, but I mean that sincerely. All of us do employment cases as well as labor arbitration. In the employment context, we're often deciding matters of law, all right? And in a courtroom, dispositive motions are fairly common. The concept of labor arbitration, the predicate is so different. I mean, in the 1940s, and I wasn't arbitrating, I know it looks like it sometimes. In the 1940s, you had what's called the War Labor Boards. And what these entities were designed to do, because of the war effort, and you couldn't stop production. You had to have production for the, to process the war, to fight the war. And so what you would do is, you had a dispute, company wants to fire John Smith, the union says, no, he shouldn't be fired, he's a manufacturing worker. Literally, get on the phone, call up Joe Jones, come on down, you're the arbitrator, he was an arbitrator, he comes down, tell me your side, tell me your side. At the end of the hour or two discussion, he said, okay, you're right, go back to work, you're wrong, you're fired. And out of that grew the notion, more than a notion, the precept that arbitration is supposed to be, as was said, efficient, streamlined, with full due process considerations, but letting everybody tell the story. And as we all know, everyone in this room knows, part of the reason, the value of the arbitration process is a cathartic basis. And that's true, and that's what it should be. Let it all out. You may be dead wrong, but let it all out. And so the dispositive motion runs counter to every fiber, at least in me, as to what arbitration should be about.
I usually just say, yeah, right. I really don't entertain them on the labor forum unless it's some truly specific type of issue that is so well defined and could be severed from the rest of the hearing that you really must hear it. But usually there would be a motion a motion made before we even get to the hearing, but I do not like those at all.
Jackie?
Things like timeliness, for example. If a grievance is time barred and a party wants to raise that in advance, in a way that's a good thing. I hate to say that because it sounds like I'm encouraging preliminary motions, and I'm not. But that's one instance in which I think it is useful. But in the employment context, I think we do see it often, and there's a fallacy that you can cull the disputes. A lot of times in employment arbitration litigation, there'll be 10 causes of action. Discrimination on the basis of this, and this, breach of contract, defamation. And a lot of times there'll be a motion in which the party, the employer usually, says it's not going to eliminate the case entirely. It's not dispositive of the entire case, but it's going to really reduce the number of issues that need to go to hearing. And I've found over the years that generally is folly because the weak cases are going to fall away. And we've then wasted a lot of time and run up tons of attorney fees in dealing with cases with the causes of action that would have been disposed of readily and easily as the matter went forward.
Let me pose I'm not pushing back on what you've said because I agree with it, but I wonder if there's some tension between what the panelists have said and the notion that arbitration is dependent upon the autonomy of the parties. As we all know, arbitration doesn't come about except by agreement of the parties to arbitrate. And if that's what they want, who are we to say, no, you can't have that?
But can I interrupt? I love interrupting him. Do you want to tell your story about
No,
that?
go ahead.
Right. But if indeed there is a arbitrability provision in the CBA, you really have to address it whether or not you care to. I don't see how, again, you could sever it. Although what I usually do, if, again, it's not a very discrete, critical issue, is say, look, make your arguments with respect to arbitrability. I'll reserve on that. Address it in the award. Let's move to the merits. You have me all day. You're paying my fee all day. I don't want to have to come back here and have you, charge you again. And usually that takes care of it for me.
I mean, I agree with that, but I also think there's a difference between simply having an arbitration clause, and yes, we're a creature of the contract, and the parties set, they basically set their rules. That's a slight exaggeration. But that's far different from listening, more than listening, far different from wasting everybody's time, effort, and money by items that are either frivolous or will be covered in the main part of the case anyway in a different form. I mean, as I said to two people before, the most important thing you can do in this whole process is know your arbitrator. There are some arbitrators, and I say this with actual affection, they sit there, their role, they say, is not to try and settle cases, not to really rule very much, just to let everybody go and have their day in court. And they have 10-day hearings, and I can't abide that. And there are other arbitrators who are, run what I call a crisp hearing. I prefer the latter, but others don't, and you have to know who you're picking.
Jackie, any last comment on this one?
I really like the term crisp. I like that a lot. On dispositive motions, just one thought that occurs to me, and I'm still kind of back in employment arbitration land, but not always, is also the recognition that there is no easy appeal of an arbitration award. There is vacatur, which is far more complicated than appeal. So if we're comparing it to dispositive motions in court, the interesting thing there is the person whose action is dismissed or denied on a dispositive motion, they can appeal that. In arbitration, they can't, and no one's argued yet that an arbitration award that did not involve a hearing is somehow subject to some different standard of review. Again, not that I think it should be, but I think the fact that this is final is significant when we're dealing with motions like that.
I can give you the names of a few federal district court judges that did not find my award to be final.
With that, let me move back to you, Rosemary. And the final question I want to put to you is, what should we be seeing with what is probably one of the most important issues facing us today, the question of diversity, equity, and inclusion? What should we be seeing from the parties with regard to the grievance arbitration process?
If, as advocates, you receive a list of potential arbitrators and either you recognize too many of them and you know they're not diverse, call the agency, ask to please supply the names of, at least if it's a panel of 10, or rather a list of 10, 3 names of diverse arbitrators. And I don't know if you're going into the initiatives, but I know so many groups are now agreeing that at least, for example, 30% would be a goal. 30% of the arbitrators that will be offered to the parties will be diverse. Again, you still have that problem of the advocate who will say, well, I don't know this person, I'm not going to use it. Eventually, though, I think that will be overcome. I'm hoping that will be overcome.
Howard?
No, I'm sorry. I was going to say something else, totally unrelated.
Well, with regard to this, Rosemary made an allusion to this at the beginning. There is an initiative that is directly speaking to the question of diversity in the selection of arbitrators. It's called the RCI, the Ray Corollary Initiative. Some of you may have heard about it. The name first comes from the first woman to graduate from Howard University in 1872, and she was also the first black woman to be admitted to a bar in the United States. She was admitted to the DC bar. So I named it the Ray Corollary Initiative. The mission of the Ray Corollary Initiative is, as Rosemary said, those who are appointing arbitrators, those who are selecting arbitrators, either off of a roster from an agency or creating your own rosters, as many of you do after you complete collective bargaining, that you commit yourselves to making that selection list 30% diverse. And diverse is, if you want to know the definition, I won't go into all the details here, but look at ABA Resolution 105. That is the definition of diverse neutrals that is being used. And empirical evidence shows that if that list is 30% diverse, the chances of selecting a diverse arbitrator goes up astronomically. Absent that 30%, the opposite is true. The chances of a diverse arbitrator being selected goes to almost zero. So, as to the question that we all hear, I won't choose someone I know. I welcome you all to come to those of you who appoint arbitrators, both labor and management. At Howard University on May 16th, 2023, from 6 to 9, there will be an event in which you will have an opportunity to meet the next generation of arbitrators. I invite you to make an appointment. Afterwards, I can give you the registration. It will be an opportunity to begin to change the language from exclusion to inclusion. Part of it will be Zoom, but the part that you need to be there. The first part will be an educational program. The second part will be the opportunity to meet people. That's one of the important barriers that the Ray Corollary Initiative is attempting to erode. Howard, you want the last?
Yeah, I just want to say two quick things. It's different from what's been said before. First, I think you have to appreciate that we're really in, putting aside the chaos in the country and the world, we're also in pretty interesting and I think fertile labor relation times. I read an article the other day that the Democrats have a supermajority, I'm reflecting my biases, but the Democrats have a supermajority in the state legislature, and they're doing some dumb things in my view, but that's not the issue. They have on the table for serious, maybe it'll pass, maybe it won't, maybe it'll be vetoed, but for serious consideration to allowing public sector employees in the state to strike. That's huge, that's enormous. And I think you just have to appreciate, now maybe this will end in November of 2024, who the hell knows, but you have to appreciate that there are really dynamic times in labor relations going on now that we haven't seen in a very long time. And the final thing I want to say is, thank you, it's 6 o'clock on a Sunday and you're staying and listening to this stuff. It's amazing. Thanks a lot, guys, I appreciate it.
With that, let me open it up to your questions for anybody on the panel. And there's a microphone that Bill's got, so if you'll just stand in the back there. And tell us where you're coming from, please. Your name?
Hi, my name's Daniel. I'm an undergraduate at Hunter College. I'm not sure, I wasn't here for the introduction. I don't know if any of y'all were arbitrators before 2009, but I was wondering if y'all could say if you've noticed any differences since 14 Penn Plaza in the existence of waivers for a union member to be able to arbitrate and to pursue a claim in federal court instead of arbitration, if you've seen an increase in these waivers since 2009. Thanks.
Yeah, it's a good question. I have. For those of you who don't know, 14 Penn Plaza is also called Pyatt, and it's ultimately Supreme Court decision relating to the rights of employees to arbitrate claims of alleged discrimination of one kind or another, where the union who holds the collective bargaining rights and holds the sole right to go to arbitration says to the employee, no, we're not going, okay? And what some places have done, and comes directly out of Pyatt and 14 Penn Plaza, the union has set up a separate procedure for employees in that category. The union has told them no, to go ahead, hire their own counsel at union expense, and have those counsels go before any of a list of arbitrators. And what's interesting to me, and maybe Jack and Rosemary have slightly different experience, what's interesting to me is that after '09, I had a spate of those kind of cases. I had a lot of them. I would say in the last 5 years, the number has dwindled to just, one or two.
I guess the one thing that bothered me was that, yes, there are certain unions that will, pay for the counsel so that a grievant could have his or her day in court. But I've run into situations where they are not paying, and the grievant is responsible. The grievant's out of work. Where are they supposed to get that kind of money? Especially if they, as Jackie would say, folly and go after an attorney who's personal injury or, something along that line, and they're going to get soaked. And, those break your heart. Those really do.
Yeah. Jackie?
Well, I think it's important to know that we're talking usually about statutory claims that are, the question being whether that employee has the opportunity to pursue that statutory claim outside the context of the collective bargaining agreement's arbitration system. And so a Pyatt clause would be one that says, no, only the arbitration that's provided for under the collective bargaining agreement. And then the question, as Howard described it, is when the union says no. When Pyatt was first decided, there was great concern about who will hear these cases, who will the arbitrators be, because a lot of labor arbitrators don't have a background in employment litigation. And these cases tend to involve certain elements of discovery. They might involve punitive damages, attorney fees. And so there was a focus, I think, within the Academy and also at the American Arbitration Association to say, we better assemble a panel of arbitrators who are ready to hear cases like this. And I was involved at the American Arbitration Association of the initial efforts to assemble that panel. And then we thought, well, let's wait and see if these cases actually materialize. And then they didn't. And so it didn't go anywhere.
I should have done this at the outset. By a show of hands, how many of you are management first, and then I'm going to seek the number of union representatives? Okay. And the number of labor representatives? Okay. Any neutrals? Further questions? In the back, Bill. There was one right here, and then in the back.
Good afternoon. I'm just curious how much pushback you might appreciate from advocates when it comes to virtual hearings. I have a couple of examples, but let's call them hypothetical. We have one arbitrator, but I'm Kathy Sheffield. I'm with California Faculty Association. Nice to see you, Arbitrator LaRue. It's been a while. We have an arbitrator on our panel who wants to resume in-person hearings, and we have a grievant who's coming up for a hearing soon who really does not feel comfortable with that. And I think we may work out something where only she appears virtually, but that just seems really off to me to have only the grievant appearing virtually or through video conference. And the other hypothetical would be, I work with an advocate who really believes that, you got to look them in the eye and you got to do, really fierce cross-examination, especially when it comes to cases of job loss and credibility of witnesses. And, might want to push back with arbitrators who want to stay doing virtual. How much pushback and changing things up would you appreciate from advocates?
Who wants to start? Because I'm very opinionated.
Yeah, you do. Well, you go ahead.
My view is that the arbitrator is not a potted plant and should be willing to manage the process. and therefore should be willing to make a decision, having heard the parties and weighed the equities of the arguments. If the parties want a virtual hearing, there are reasons for it, and the arbitrator ought to go along with it, I think, and vice versa. If there's good reason to hold the virtual hearing, be it health or just a situation that the parties raise, then, as you know, as Jackie indicated, I'm a strong proponent that the virtual hearing has a place and it ought not be dismissed as a way of carrying out the arbitration process out of hand.
I mean, the arbitrator's empowered to make the final decision if indeed there is a dispute between the parties as to how it should be done. And again, after weighing the relative equities and so forth, the arbitrator has to make a decision.
I'll say one thing if I could. The credibility argument, I hold no weight whatsoever. All the empirical evidence says that an arbitrator, any decision maker, should not be making credibility findings based upon demeanor. It's culturally biased, it's biased in so many ways, and there are so many more valid ways of weighing credibility.
I don't know if you all were at that session with the National Academy where they brought in the FBI to run little vignettes, I think 10 or 12, and there were 300 arbitrators in the room, and we had to decide whether or not the witness is credible. And we didn't find out the answers to the end. I think there were only 3 arbitrators that had it right, and maybe 5 that had a majority. I mean, people could be really good actors. So, or they could be nervous and be sweating on the stand. I mean, or stutter. I mean, there's so many things, but, so as vis-a-vis the using virtual, I can even see you closer. So I don't see why that's an issue.
To answer your question, I use a very simple test. I prefer virtual. Obviously, it's easier. And then I can wear jeans and a tie and a shirt. But thank you, dear. This is Dorothy and Dick or Gracie and George, and I think I'm Gracie right now. But in any event, I really do. Very simple test. I prefer virtual. If both parties want in person, that's fine. I'll go. That's what they want. But if it's a tie, so to speak, then I'll do it virtually.
One last point I would make on that is that I think labor management and neutrals ought to, going forward, be in some sort of discussion and dialogue about virtual hearings and begin to really study this process going forward and not make it simply something that came out of the pandemic. We have time for one last question.
Hi, I'm Patrick Bryant. I'm a union side advocate lawyer. I have not had the pleasure of appearing before any of you, which also means none of you have had the displeasure of tolerating me in a hearing. And even though I've been practicing for 20 years, I'm increasingly convinced that arbitration is completely unpredictable. And one thing that often, I guess, I think about is the sort of feedback process on sort of both sides. And I still question what's effective advocacy. And there's certain things I get frustrated with in arbitrators. And I'm wondering if you have had formal or informal kind of feedback processes or can point to examples in which you have grown or learned from some kind of feedback and maybe what you think could be beneficial to do in that way.
Yeah, I think it's a shame that the American Arbitration Association does collect information. I don't know if it's just on employment arbitrators with respect to, how the hearing went, what did they think of the arbitrator and sort of, but we never hear about it unless it's a gross negligent or a serious thing. The way I usually figure it out is if they don't use me anymore, they don't like it. And that's, usually it's a very simple way. Or you hear scuttlebutt in the community. Townley did this, or Edelman did that, Jackie. But there's not much of that.
I think you're dead right in terms of the feedback, and I would welcome feedback, but I really would prefer bilateral feedback. I'd be happy to sit down with both advocates after an award was rendered you screwed up here, you didn't screw up here, and get it that way. So I think feedback, and look, I'm sure, and when I say I've made mistakes, not only have I hopefully rarely made mistakes in terms of the ultimate decision, but I'm sure I've made mistakes going along the way and making assumptions that were just not accurate, you know? And I can only tell you this anecdote. So this advocate calls me up and he says, boy, that was terrible, it was awful, it was the worst decision about it. I said, don't worry, you'll get worse ones. So and that was how we ended.
Jackie, what?
There are the rare instances in which we can serve on 3 arbitrator panels. It's pretty rare in labor. They're tripartite, but usually it's a party representative serving as wings. But there are times in the employment arena where there are 3 fully neutral arbitrators functioning. And that's a wonderful opportunity to kind of compare notes, to observe, to get feedback from your colleagues. Rosemary and I were actually on a panel with another arbitrator who also talking about being in a room with only women, which was interesting. This was a 3-arbitrator panel in which it was the 2 of us and another woman, Susan. We were gathered, and this was, I don't know, 15 years ago maybe? Yeah. And so speaking of the lack of diversity and also the arbitrators, you know, the 3 of us were gathered outside the arbitration hearing room, and we were conferring, and a very well-known advocate came walking by, kind of as walking by, looking at the 3 of us, short, dark-haired female arbitrators, kind of looked at us as a group, Rosemary, Susan, and myself, and said, hello, Marjorie, and kept going. Not a one of us was Marjorie. And it was, oh, such a good guess, but you're wrong.
The final answer I will give you is that the Academy, and this is an invitation to come to our next meeting, the Academy often invites advocates to do exactly that, to give feedback to Academy members on what they've done, what's right, what's wrong, what's ugly. And so May 4th to the 6th, Denver, Colorado. Be there. With that, we're going to close out so that I can keep my record of always being on time. Thank you very much for your time and your attention.